Assalamualaikum warahmatullahi wabarakatuh. Inshallah, today we will review a case of Genneva, Malaysia Sendirian Berhad versus Theo Jit Hong and others. This is the video facts of the case. This is the respondent in our case, represented Theo Jit Hong and others. This is our appellant in our case, represented Genneva, Malaysia Sendirian Berhad. One day, the respondent and the appellant made a contract to buy and sell gold. The respondent then paid the money for the gold to the appellant's bank account. However, the appellant failed to deliver the gold to the respondent. The respondents also claim that they sold gold to the appellant, but the appellant failed to pay for the said gold. The respondent's decision was granted by the High Court. The appellant was additionally directed to pay 5% interest on the amount granted to each respondent based on the date of the customer purchase orders and customer purchase bill. The appellant then filed an appeal after being dissatisfied with the ruling of the High Court. The appellant argued in the current case that firstly, the appellant did not accept the offer. There was no proof of a binding contract between the parties. Secondly, the learned judge failed in refusing to consider that the respondents had not received the public prosecutor's consent. Lastly, the learned judge further erred by failing to consider the respondents' delay in bringing the current case, which began approximately 6 years after the alleged breach by the appellant and was brought without explanation. So, what is the decision made by the court? Let's watch the mock trial in the Court of Appeal.
Good morning. Thank you for attending the court. This is an appeal case against a judgment in favor of the plaintiff in the High Court. The respondent and the appellant signed a contract of purchase and sales of goods. Appellant failed to pay the money as well as handing over the gold to the respondent. Therefore, the appellant, Genneva, Malaysia Sendirian Berhad, was summoned by 9 respondents. Due to the decision in the High Court in favor of the plaintiff, the appellant made an immediate appeal on the matter to be defended. The trial was judged by the Honorable Judge Hamid Sultan Abu Bakar, Hanifah Fakirullah, and Kamaluddin Mat Said. All rise. Thank you. You may be seated. Court now in session. Today, the court will hear the case of Genneva, Malaysia Sendirian Berhad versus Theo Jit Hong and others. Is the appellant lawyer ready?
Yes, Your Honor.
Is the respondent lawyer ready?
Yes, Your Honor.
We will now hear opening statement from the appellant lawyer and respondent lawyer.
Good morning, Your Honor, ladies and gentlemen. My name is Amira Farisa binti Zulkarnain and I am representing my client, Genneva, Malaysia Sendirian Berhad in this case. First of all, my client is presumed innocent until proven guilty. On 28 September 2018, my client, Genneva, Malaysia Sendirian Berhad, was sued by the first to 7th respondent on 27 September 2018 and by the 8th and 9th respondent on 28 September 2018 respectively. The respondents claim against the appellant the payment of monies owed to them or alternatively payment by restitution. However, the appellant opposed to the application on 19 October 2018, amongst others. But the same defense as raised in the statement of the defense, and based on the defense, the appellant argued that there are three issues to be tried related to the existence of contract between the respondent and the appellant. That it is the restriction imposed under the Anti-Money Laundering Act 2001, AMLA, and latches. It was the appellant's case that the three issues ought to be determined on a full trial basis.
Okay, good morning, Your Honor, ladies and gentlemen. My name is Umul Nadia binti Pambi, and I will be here as the lawyer for the respondent, Teo Ji Hong and others in this case. My client alleged that they had entered into contracts with the appellant to buy and sell gold to the appellant. They had deposited a sum of money into the appellant's CIMB Islamic Bank account. However, the appellant failed to deliver their obligation and also their responsibility towards the respondents. The respondents also claimed that they sold the gold to the Genneva, Malaysia Berhad, but they failed to pay for the said gold. So the respondents had filed an application of summary judgment towards the appellant, and it can be allowed on the basis that the facts established in the pleading. The pleading clearly showed there is no triable matter issue. However, this case has been brought again by Genneva, Malaysia Sendirian Berhad, as they decided to make an appeal for this case.
The trial will begin now.
Today, I would like to appeal for my client's case and intend to deal with a few grounds appeals. Firstly, the appellant and the respondent had no contract because there is no written acceptance by the respondent. For the appellant, the customer purchase orders are mere offers to sell gold to the appellant. All the customer purchase orders contain a clause, I or we hereby declare that this order does not bind Genneva until it is accepted in writing by Genneva. However, none of respondents adduced any evidence at all of the acceptance by the appellant. Therefore, there is no evidence of any binding contract between the respondent and the appellant. I relied on the High Court case of Genneva, Malaysia Sendirian Berhad versus Abdul Ghani Sheikh Mohammed, 2018, where the facts were similar to this present case, and the learned judge held that based on the circumstances of this instant appeal before me, it is my respectful view that the argument of the respondent thought well argued, do not hold water and cannot be sustained. My reason are these. The starting point is the customer purchase order relied on by the respondent is only an offer to purchase. This is crystal clear from the express wording of the customer purchase order highlighted by the appellant, such as, first, the heading is customer purchase order. Secondly, the legend is I or we hereby declare that I or we am or are aware that this offer does not bind Genneva until it is accepted in writing by Genneva. And the third one is the clause that is I hereby acknowledge receipt of the buyer's order. This present case should be decided on its peculiar facts, where it is clear that the customer purchase order was only an offer and shall not bind respondent until it is accepted in writing, that is by way of a sale and purchase agreement. I find there is much force in the submission of the appellant, as it is my respectful view that the appellant case is a case where the condition of acceptance clause of I or we hereby declare that we are aware that this offer does not bind Genneva until it is accepted in writing Genneva falls under the first category. To borrow the words of Von Harvard, in the Birch case, which was advocated by the federal court in Lim Keng Seong's case, is a condition of a term of the bargain and not under the second category of a mere expression of the desire of the parties as to the manner in which the transaction already agreed to will in fact go through. The argument canvassed by the respondent. For the reason given above, with respect, I disagree with the respondent's submission that a contract to purchase gold was formed on 20th September 2020 and signing of the formal sale and purchase agreement was a mere formality. By the same token, I find the learned session court judge has erred in her find that a valid contract to purchase the gold had come into existence on 20th September 2020. Therefore, the learned judge erred is not considering the said clause in the customer purchase order.
With the court's permission, I would like to reserve for several minutes for rebuttal.
Yes, please.
The appellant's argument that there is no contract because there is no written acceptance by the respondents is misconceived. It is because the law is tried apart from writings, because the conduct of parties may amount to acceptance. The illustration for this case is all the customer purchase and orders and that are considered as offers made by the respondents. These offers were followed by the payments into the appellant's bank account and some by partly giving gold at an agreed value. The appellant accepted the payments and did not reject the payments. The appellants did not return the payment. Instead, the appellant kept the payments and used them to the appellant's benefit, which is considered as a conduct. This is also considered as an acceptance. All at the same time, the respondents were not given what was promised for the said payments. Hence, this issue is not triable issue and there is surely a contract binding between them.
Now, I will proceed with the second appeal. Members of the jury, my client here wants to appeal this matter that it was argued that alternatively, the respondents are claiming for a refund of their monies paid to the appellant, that is restitution. Their claim is therefore for refund of the monies that they allege to have been deposited into the appellant's account with CIMB Islamic Bank account number 1456000662104. The monies in this account have been frozen under Section 50, subsection 1 of the Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001, that is AMLA. For this claim of restitution, Section 54, subsection 3 of AMLA requires them to obtain the consent of the public prosecutor. However, the consent that the respondent has obtained from the public prosecutor is only for their claim for breach of contract, that is, the contract of sale and purchase of gold between the respondent and the appellant and not for the restitution. The learned High Court judge erred in failing to consider that the respondent had not obtained the consent of the public prosecutor as required under Section 54, subsection 3 of the Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activity Act 2001. Section 54, subsection 3 provide as follows. For so long as a seizure of any property under this Act remain in force, no action, suit or other proceeding of a civil nature shall be instituted, or if it pending immediately before such seizure, be maintained or continue in any court or before any other authority in respect of the property which has been so seized and no attachment, execution or other similar process shall be commenced, or if any such process impending immediately before the such seizure be maintained or continued. In respect of such property on account of any claim, judgment or decree, regardless whether such claim was met or such judgment or decree was given before or after such seizure was effected, except at the instant of the federal government of the government of a state, or at the instant of a local authority of other stationary authority, or except with the prior consent in writing of the public prosecutor. From a reading Section 54 of AMLA, it is clear that so long as a seizure of any property under this AMLA remains in force, no action or suit or other proceeding of a civil nature shall be instituted, or if it is pending immediately before such seizure, be maintained or continued in any court of before any other authority in respect of the property which has been so seized. At the time of institution of this suit and the trial of the action, the second order was still subsisting, and therefore the freezing of the first defendant's CIMB account was effective and in force. The respondent have not obtained the required prior consent of the public prosecutor as required under Section 54, Section 3 of AMLA. As such, I find that the institution of this suit is contrary to the prohibition under the said Section 54, subsection 3 of AMLA, and the action cannot be maintained.
May I rebut the grounded appeal?
Yes, please.
Okay. The case does not involve or relate to the property sales, and as such, there is no need for a prior consent in writing of the public prosecutor under the Section 54, subsection 3 of AMLA. However, in abundance of caution, my clients had obtained the requisite consent under Section 54, subsection 3 of AMLA. The consent truly applies only if the claim by my clients is in respect of the property of the appellant, which has been seized. In this regard, the correct interpretation according to the respondents was given in Datuk Zahari Sulaiman versus Genneva Sendirian Berhad by the learned judge in allowing summary judgment. Therefore, the consent issue as raised by the appellant is clearly not a tribal issue. That's all.
Your Honor, can I proceed with another ground of appeal?
Yes, you please.
Thank you, Judge. Ladies and gentlemen of the jury, this is my last appeal for my client. My client wants to appeal this matter that it was argued that the learned judge also erred by not considering the delay in filing this suit. In this case, the respondent filed this suit almost 6 years after the date of the alleged breach by the appellant without any explanation for the long delay. In the case of Lim Chiu versus Lee Chow Yong and Honor and another appeal, 2018, the Court of Appeal held as follows. It is tried that inordinate delay without explanation is in itself fatal to the application under the Section 279 of the RTA. This was held by Ramli Ali J in Abric Project Management Sendirian Berhad versus Palm Shine Plaza Sendirian Berhad and Anor, 2007. Where the court is dismissing an application under Section 279 of the RCA, held that there was clear delay in the filing of Enclosure 37. Enclosure 37 was only filed on 27 December 2005, where evidence suggests that the applicant knew of the sale of the said land at least as early as 20 August 2004. It is therefore unreasonable for the applicant to have now awake from this slumber over 2.5 years later to begin to question and interfere with the decision with hindsight. The learned judge also erred when the Lordship failed to appreciate that the second, third, fourth, and fifth respondent have not tendered any evidence of delivery of the gold that they allege to have sold to the appellant. The first respondent has tendered a customer sales from a customer purchase bill as evidence of sale of gold to the appellant, whereas the sixth respondent has tendered only a customer purchase bill. There is no clear evidence of delivery of the gold to the appellant. Therefore, it was submitted that the appellant has a defense on merits and there are several triable issues. This case is not suitable to decide under 0.14 of RORC 2012, and this matter should be reverted to the High Court for trial, full trial. Thank you.
I am sorry to interrupt. The respondents had submitted that the respondent's claim has been made well within the prescribed period by law. It is not as stated by the appellant that my clients filed a claim after 6 years of the transaction and exceeded the time limit. It was argued that the appellant's only substantive defense is the seizure under AMLA. However, as pointed out earlier, the claims by the respondents are not for the properties under the seizure. The seizure actually does not affect the appellant's liability to the respondents. In fact, by this defense, it is an acknowledgement by the appellant, Genneva, Malaysia Sendirian Berhad, that if the claims had been made sooner or before the seizure, the appellant will have refunded the money and returned the gold to the appellant. That's all from me.
Appellant lawyer, do you have any other issue to appeal?
No, Your Honor.
Respondent lawyer, do you have anything to say?
No, Your Honor.
We found there is no tribal issue in the plaintiff application for summary judgment on the claim against the defendant that merit a full trial. Besides that, the plaintiff had a clear and undeniable claim. The court agreed with the respondent that the claim had been made well within the prescribed period by law. It is our decision that the appeal is dismissed with cost 10,000 ringgit Malaysia subject to the allocator. The High Court discussion is affirmed. All right.